Negligence, which is also part of torts, is duty, breach, causation, and harm. Negligence occurs when there's a failure to act as a reasonably prudent and careful person is expected to act in similar circumstances. So there has to be a duty, there must be a breach, causation, and harm. But under certain circumstances, the duty may be different because we look at how would a person have acted in a similar circumstance. So when faced with an emergency, a person is not required to use the same mature judgment that is expected under circumstances where there is an opportunity to deliberate. What that means is that a person who is faced with a gun, let's say a taxi cab driver, a thief gets in the back seat, the gun is drawn, and they tell the taxi driver to go. Well, the taxi driver jumps out, abandons the vehicle, the car is still in drive, and it crashes into a woman and her two children down the road. The woman rather, and her two children then sued the taxi driver and the taxi company, arguing negligence. And the court said, well, when faced with an emergency, which clearly that was an emergency, you don't have the same duty because you don't have the same time to deliberate your decision. He didn't say, well, there's a man in the backseat with a gun. What shall I do? Most people who are facing an emergency don't necessarily have the ability to deliberate as they would had that emergency not presented itself. So the court recognizes that when we speak about duty. Now, breach is just that. You had this duty and you didn't do it, therefore there was a breach. However, we do have this thing called res ipsa loquitur under breach, and it means literally the thing speaks for itself. It's Latin, and it says that negligence is presumed because this event wouldn't ordinarily happen. So if I'm walking down the street and a piano flies out of the window and it crashes on the ground and I'm hit by shards of wood and I suffer lacerations and damages to my body and skin, at that particular point, I don't have to prove that there was a breach because at that point, it speaks for itself because pianos do not fly out of windows. So what I have to figure out is who's responsible, but not that there was a breach because the negligence would be presumed because this does not ordinarily happen. So we have duty, we have breach, we have causation. Causation comes in different forms. So you have actual causation, which we call the but for. But for the defendant's actions, this negligent injury would not have occurred. That's the actual causation, the but for. They did it. Now, proximate causation deals with foreseeability. Was it foreseeably related as to justify the so the foreseeability? Was it foreseeable what happened? Okay, so we have but for actual, and once actual is found as a policy matter, we now look at was the harm foreseeably related as to justify a finding of liability. So this goes to the Palsgraf case. The Palsgraf case is a man who is in the train station and he is trying to get on the train. Well, a man who works for the train company because it's the Long Island Railroad who was sued by Palsgraf. So he attempts to help the man catch the train. So he pushes him from behind into the train as the doors are closing. So as the man pushes him, the train worker, the man who is carrying a briefcase drops his briefcase. Okay? So he drops his briefcase. It explodes because it has fireworks. The fireworks explosion then ricochets, hits the ceiling, and then all the way down the platform, many, many feet away, is a Palsgraf who is struck in the head based on this explosion. Now, at that particular point, she then sues. And the court says, was the train company, because they're using the vicarious liability respondeat superior to impute damages to the Long Island Railroad Company, so was the company responsible? Okay, yes, he pushed him, and but for him pushing, he would not have dropped his briefcase. That's the but for, the actual cause. But the proximate cause is the problem. The court said it's too far removed because there was no way that he could have known that, hey, if I push this man, he may drop his briefcase, and his briefcase probably has fireworks, and those fireworks are going to go off. They'll probably hit the ceiling and then ricochet all the way down the platform, and someone will be hit in the head. So the court said, while there may be actual cause, the package didn't necessarily demonstrate, he could not tell that it had the potency of peril. He also couldn't foresee that there would be any damages or any harm to the person all the way down the platform based on the scaffolding, because it was just not foreseeable. So while the employee may have been negligent for pushing, there was no foreseeable harm to the plaintiff, whose pause graph, who was all the way down the platform. So the court says, while we get actual cause, in order for you to have cause, we also need proximate cause, meaning the foreseeability piece. Okay. We also have, under foreseeability, intervening cause, intervening and superseding. Intervening causation is if intervening cause is great enough, the defendant's negligence may no longer be the proximate cause. It becomes superseding. Okay, if the intervening cause is foreseeable, then the defendant may still be liable. So we have intervening and superseding. So to give you an example, intervening causation. The individual is driving a vehicle. So we have person A. Person A is driving their car. They rear end person B. Okay, so that right there is a breach. You had a duty to be a prudent driver. You did not. You ran into driver B. Driver B is substantially injured, significant injuries. There is a substantial risk to her health at this particular point. So they call 911 and the ambulance is dispatched. The ambulance shows up. Driver B gets into the ambulance. The ambulance is en route to the hospital, and unbeknownst to that person, the ambulance is hit again. And now the person, driver B, suffers additional injuries. Okay? So let's say the car, the vehicle that hit the ambulance, that hit driver A, let's say driver A was Taylor Swift. And then the driver that hit the ambulance, which we will refer to as driver C, is just a regular old Joe. So the reason why we would want to use intervening causation is because now I've been hit twice by driver A, who I've now identified as Taylor Swift, and then by driver C. So driver C does not have deep pockets. Whenever a person is suing under negligence, we are suing for money, for damages. Remember, that's the harm. The harm is, how do we value this? We value it in damages. If I want to sue, I want to sue the person that has the deep pockets. So if I can get back to driver A, Taylor Swift, she probably has deeper pockets than driver C, who just had this ambulance, who I told you is just a regular old Joe. So at this particular point, if I can use intervening causation to say that it was foreseeable, okay, that it would happen, that this third party negligence was kind of foreseeable, then we can keep the chain and it all goes back to driver A, Taylor Swift. So she would be responsible for hitting driver B. She would also be responsible for the injuries I sustained from driver C, who hit me, because it was foreseeable maybe that the ambulance would be in another accident. Same holds true for, let's say I get to the hospital. I have a doctor. That doctor performs surgery, and somehow the doctor does it incorrectly, and now I'm messed up for life. At that particular point, the question becomes, intervening causation keeps the chain all connected to the original tortfeasor. We would only employ that if the original tortfeasor perhaps had the deep pockets. That would be one reason why a practitioner would want to do that. But it doesn't mean that if the court doesn't buy the intervening causation, then it breaks the chain and that superseding causation, and now we just have two separate suits. So I would sue driver A, Taylor Swift, for that accident, and then I would sue driver C for hitting the ambulance and causing additional injuries. I would sue driver A, Taylor Swift, for the accident, or in my second example, sue the doctor for medical malpractice. But if we can see or put them together and say that they are connected, then at that particular point, it is intervening causation that keeps the chain back to the original tortfeasor. So there was a case where the Department of Transportation had a little dip in the road. So there was a woman who had been traveling. She went through the dip because when it rained really hard, it created a puddle. She goes through the puddle and her car stalls out because the rainwater. So she's pulled over to the side of the road. She's in her car and she has her children. So she's facing, let's say, north. So she sees a driver who is driving the opposite direction. He comes, he witnesses the woman on the side of the road, sees her children, and he wants to be a good Samaritan, so he helps. He goes to make a U turn, which means he U turns at the end of the road and he too goes through the puddle. When he goes through the puddle, he hydroplanes into the woman, okay, pinning her between his car and her legs then had to be amputated. So instead of suing the Good Samaritan, she sues the Department of Transportation. And she says because they were aware of this and they, under intervening causation, it was foreseeable that with this puddle and the water pooling, that another injury would result. And so the State Department was liable because the injuries were foreseeable, although not the proximate cause. They should have known that the pool of water on a highway poses a substantial hazard, is what the court said. So, duty, breach, causation, and harm. Now, duty to third parties. Do you owe a duty to a third party? The court has looked at this on numerous occasions. In fact, it came up again in Maryland, where bar owners or tavern owners, are they responsible if an intoxicated patron negligently injures a third party? These are called dram shop laws. The court has said that this is not the court's wheelhouse, that the legislative branch of government needs to address it. So when it came up again in 2013, again, they said that tavern owners will not be responsible for the negligent actions of a third party. Now, I mentioned Good Samaritan. We encourage Good Samaritans to help out. Do you have a duty to help out? No, but only if there's a special relationship, like a parent and child. Okay, that creates a duty. But if a Good Samaritan attempts to help an individual, we do not hold them responsible for injuries caused by their ordinary negligence. However, they are not relieved of gross negligence or intentional misconduct. So if you are going to perform a procedure on someone who needs it and the procedure is something that you saw on the internet, it is not in the ordinary standard of care. It is just something that you've done, or you're like, hey, that person is down, let me punch them in the face and then I'll help them. Those are not going to be, you're not deemed not liable for that. That would be considered gross negligence or intentional conduct, and so Good Samaritans are responsible for that. But if we relieve them of their responsibility if they cause injury, as long as it's ordinary negligence. Now, there are defenses to negligence. Defenses to negligence are contributory negligence, assumption of the risk, and comparative negligence. Contributory negligence is negligence by the plaintiff that contributed to his or her injury. Okay? It bars the plaintiff from recovery. Maryland is a contributory negligent state. Maryland is in the minority. The assumption of risk and comparative negligence are also defenses. Comparative negligence says that we measure the relative negligence of the plaintiff and the defendant, okay, and they share the responsibility. And whoever is more negligent, so if defendant is more negligent, then they pay. Assumption of the risk is that the plaintiff knew about the nature and the danger and voluntarily exposed themselves to it, so therefore they cannot argue that somehow it was negligent. But it is important to know that contributory negligent, if found that you contributed to your own negligence, you are barred from recovery in a contributory negligent state, which Maryland is a contributory negligent state. If you are in a comparative negligent state, then we measure negligence and we share the compensation for injury. So it means that you will not necessarily be awarded as much in damages as you would have had you not contributed, but you would get something in a comparative negligent state. You would not in contributory negligent state.